First case on this morning's docket, case number 112834, State of Kansas v. Kenneth Boysaw.
May it please the court, Corinne Gunning from the Appellate Defender Office, appearing on behalf of Mr. Boysaw. I would like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Okay. Brief factual background. In 2013, Mr. Boysaw was charged with a single count of aggravated indecent liberties with a child, an off-grade felony, and a jury convicted him of that charge that same year. The evidence was that Mr. Boysaw inappropriately touched a 6-year-old girl who was related to someone who lived in his apartment complex. During that trial, the state was allowed to present evidence of a 1987 Nebraska conviction that he had previously for sexual assault of a child. His attorney argued first that the statute allowing for propensity evidence in a case charging a sex offense was unconstitutional, as well as that the evidence of that prior offense was more prejudicial than probative and should not be allowed, especially given the amount of time that had passed between 1987 and 2013. The court allowed that evidence in, and Mr. Boysaw was convicted at sentencing based on that prior conviction. The court found, as well as another conviction, the court found that Mr. Boysaw was an aggravated habitual sex offender and sentenced him to serve the rest of his life in prison without the possibility of parole. I raised several issues in the brief and the petition, and I'm prepared to discuss all of them based on the interest of the court, but unless this court directs otherwise, I'll focus on the constitutional challenge to KSA 6455D and the specific evidentiary challenge in this case to the conviction that was allowed. For a constitutional challenge to a statute, this court exercises unlimited review of that. I believe this court is aware of the history of KSA 6455. It was passed into law in 1963, codifying the common law. It put into law here in Kansas law that has been well recognized for quite some time in the U.S. Common law, federal law, prohibiting the introduction of propensity evidence in a criminal case. While Kansas has historically had a lewd disposition exception that allowed evidence in cases where a defendant is charged with a sex offense to prove his lustful disposition, often that was not the only reason that evidence was allowed in, and it was not generally to only show the propensity of the offender to commit a sex offense.
Why was it allowed in? I mean, we have a lengthy history of, for lack of a better description of how our cases described it, was lustful dispositions well back to turn of the century, kinds of exceptions that seem to say that yes, propensity evidence isn't allowed in prosecutions but for cases involving sexual crimes against children or rape and those other kinds of cases. We have a rich history of allowing that in, really since statehood.
Yes, I recognize the existence of the lustful disposition. In my reading of several of the cases, often the lustful disposition was not solely to prove that person's propensity, but also to prove their relationship to the person, their identity, their motive, types of things that are allowed under 6455, but not solely to prove, well, this person has committed a sex offense before, and so here they are committing a sex offense again, but rather to show that there is some sort of often relationship of the parties or corroboration of witness testimony. And I would say that in that discussion, we are very similar to the Iowa history in that they also had a lustful disposition, but similarly did not allow it in for propensity evidence alone, but allowed it in for lots of other reasons. Despite the historical prohibition, I would argue.
Well, Iowa didn't have the same history we did it? In their case, they cited actually there was a prohibition against propensity evidence, and there was a gradual kind of taking away of that right through these exceptions. Kansas really started with allowing this type of evidence in. I mean, that's distinct. Iowa's history is a little different than ours.
I have a different reading of the history. It's how I see our development is that we had this lustful disposition that almost stopped at the time that KSA 6455 came in, and then there was a development after that is similar to the development of letting in certain things.
Say that again. We had a history, and then it stopped with the enactment of 6455.
That's how I see the case development.
So it wasn't the 63 enactment wasn't entirely intended, as you originally stated, to codify common law. It was going to rein it in certain respects.
It's my position as looking at the case law that I don't think that the lustful disposition allowed evidence solely for propensity evidence. And so I think that it did allow evidence in for other purposes, which I think our case law demonstrates. But when you look at the development of the case law, there's a void around 1963. And
immediately after enactment.
Yes. And then it sort of develops from there.
You may have said, but I may have missed it, was the lustful disposition common law ever challenged based on the Kansas Constitution?
Not that I was able to see.
And was lustful disposition a part of the Kansas common law in 1859 when the Kansas Constitution was passed?
I don't know 1859, but I know that the case law goes back to like 1897, discussing it. So
What I'm getting at is so what if lustful disposition was allowed in the past? Why can't we consider whether that was another word for propensity and violates our Constitution? I don't hear you arguing that.
I suppose that's probably because I'm arguing based on how the Court of Appeals made their decision.
Okay.
But I would say that I don't see any reason why this court can't simply say, of course we can say what this means. But my arguments are based just on the Court of Appeals interpretation.
The thing that bugs me about this whole issue, I mean, we're talking about using an old crime as evidence to convict someone on a new crime. And it seems like, regardless whether you go back to the beginning of the Constitution or not, there's an assumption on both sides about whether this evidence is meaningful or not for the purpose that it's being used for. There's an assumption on the statute side that this is good evidence, so therefore it comes in. My point is, for purposes of making a constitutional attack, is this the kind of issue that needs to be more developed factually? In other words, to bring in the scientific research that shows whether someone who commits a sex crime is more likely to commit it again, which is, I know, the behavioral assumptions by some. Mm-hmm. It just seems like both sides are talking past each other and not really talking about the reality, which would be, my question is kind of detrimental to you because you guys didn't come forward with that sort of evidence to say this isn't relevant. There isn't a linkage between what happened before and what we're faced with today. But is this the kind of issue, I guess, that requires that kind of development before we can do the constitutional analysis?
I don't believe so. I don't think that this should have to be, I mean, as I interpret that, that would almost be an as-applied challenge to each individual defendant. Is it unconstitutional as applied to Mr. Boysaw, rather than across the board? And I would also say, well, we also put in, I mean, this court advised the legislature to pass this type of law based on some of these assumptions without any evidence of that. I don't think that that evidence, I mean, there's more and more developing all the time, but I think that this idea that propensity evidence generally is problematic, I don't think we need to look at, is it problematic really for sex offenders? Because then you're treating sex offenders differently. No, it's just problematic. I don't think that we need to look at the evidentiary background of sex offenders reoffending. That can go into, if we get into the relevancy questions afterwards.
Well, why don't we need to know whether there is a propensity?
Well, I guess my question, my response would be, if we don't need to know if someone has a propensity to commit burglaries.
No, generally, whether there's a reason to treat sex offenders different than thieves that suffer kleptomania or others that commit crimes compulsively. Why don't we need to know if there are social facts available that would justify singling out the sex offenders for propensity evidence? Why don't we need to know that?
My position is that they shouldn't be treated differently. That it shouldn't. We don't need to see sex offenders differently than other individuals.
What if there's a rational basis for doing so? That's kind of where we are. This isn't really raised as an equal protection, but
Right.
that's kind of what I mean. That's kind of the idea is historically, like our U.S. Supreme Court has saying that recidivism is frightening and high, and so that has allowed all manner of things to happen with sex offenders that can't happen with other people. But if that isn't true, why don't we need to develop that as a fact at the trial level?
I think that from my perspective, it would be because, again, we're not looking at an equal protection question, and we're not looking, I mean, there's, I guess, lots of discussion about this in the registration context. But the question is whether or not these individuals are entitled to the same right of due process as someone who is not. And I don't think that their history of sex offenses is a relevant question as to whether or not they should be entitled to those same rights, since the presumption of innocence, the right to due process.
And the due process is you're arguing that I mean they had the same process, but they except for this, and you're saying that it's fundamentally unfair to treat them differently.
Yes, and I think that
And why is it fundamentally unfair to treat them differently if they are different?
Because my position is they're not different.
That's back to where we're talking about. Why don't you have to show that they aren't different?
Because before they are convicted of this before they're convicted of this offense, they should be entitled to the same rights as someone who is not charged with a sex offense. And if we're starting from the very beginning saying that they have fewer rights, once they have a conviction and we get into questions about registration, there's a different question. They have a conviction. But at the very beginning of the case, they should be in the same position as anyone else, any other resident of Kansas, as having the right to due process and the presumption of innocence.
I'll preface this question by saying that I'm asking a question that I struggle with. Mm-hmm. But I would like to hear your view of how do you separate propensity from evidence of intent, motive, opportunity, plan, all of the other things that we allow for all crimes to be admitted for prior crimes. It's hard for me to see how your intent is based upon the fact that you have intended to do an act that you have a pattern of doing, that type of thing. Your thoughts?
I think that I'll be honest, and I may be making some presumptions here, but I think that struggle is part of what led to this being enacted in the first place. I read that struggle play out in the first Prine decision. But what's happening is that now that we have this propensity thing, the state is not required to prove anything else. They just say, well, we can get it in for propensity. And the court's like, yeah, that's true. And so these things come in without any proving of intent. Do you have a sex offense? Are you charged with a sex offense? All right, it's in, without any discussion or wrestling with that question. I think the hardest part would be the substantial similarity between, I think that's probably the most difficult of the exceptions. But intent, you have to really actually compare the two charged offenses, the prior conviction and this one. If you're looking at motive, you have to actually compare what someone's defense is. You have to actually look at the facts of the case, and I think that's allowing propensity in is taking away most of that. So I think that it actually forces the court to wrestle with those questions if you don't have the propensity exception, which I think is what is supposed to happen. I don't know if that's helpful, but propensity is just, and it ends up looking like, well, if you have a prior sex offense conviction, it's going to come in if you're charged with a sex offense. And that ends up being the question, that there's not any wrestling with the facts at all, which I think happens with the other questions, if that helps.
Counsel, you're out of time. We've asked you a lot of questions. Do you need about 30 seconds to wrap up, or do you think you've made your points?
I believe I made my points. I would just argue that, I guess conclude that 6455D, I would request this court find it unconstitutional under the Kansas Constitution.
Do we have any further questions? Thank you, counsel.
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. I also plan to address the constitutional challenge and submit the remaining issues on the briefing unless this court has questions about those. So turning to that challenge to 6455, obviously this court is to presume that the statute is constitutional.
But by the same, let's just jump right in to
Sure.
where we were here. Why shouldn't the state be required to demonstrate the link between and the relevance between the old crime and the charged crime?
Well, I think the state still does have to do that to the extent that this court, since Prine 2, the case law does demonstrate that there still is this probative prejudicial balancing test that applies. And I think
That's against prejudice, and I'm talking really more about relevance. Almost what Justice Lukert was talking about with the pattern of this thing, showing intent by the pattern of conduct. And I understand the balancing between whether this is really, really nasty evidence, and so it shouldn't come in just because it would inflame the situation. But we're talking about why it ought to be relevant.
Well, I think I think relevance is wrapped up in the probative prejudice balancing test, and I think this case is a perfect illustration because in this particular situation, the state had sought to admit evidence of 2 prior convictions that this defendant had, and the court only allowed one of those prior convictions in, and the reason that he excluded the other one was because essentially he didn't find that the state had presented sufficient evidence indicating that that particular crime was relevant. I think that there just wasn't enough information presented by the state with respect.
Wasn't there a question of whether that crime was overturned or there was something that occurred that they didn't actually prove there was a conviction?
I don't remember the specifics other than just the court's ultimate decision was that unless the state could provide him more information with respect to it. So I think that shows that the courts are still looking to make certain that the evidence that the state is seeking to get in does have relevance and probative value to it. And so I think that would be my primary response to Your Honor's question, is that just because the statute now allows for it to come in for propensity, doesn't mean that it automatically will come in. There is still a balancing test, and that does include an assessment of whether the evidence is probative and relevant.
Such as it's too remote in time.
I think that would be part of it. I think
Too
also,
dissimilar.
yeah, this for propensity, we don't obviously have to show that it's strikingly similar or a signature act. But clearly, I can envision situations where a defendant would have a very strong argument that a certain prior conviction, even if it is also for a sex offense, is so different. If a defendant is charged with committing a crime against a 5-year-old girl, and the state's trying to get in evidence that when the defendant was 16 years old, he got charged for having sex with his 15-year-old girlfriend. Obviously, that's the type of situation where the probative prejudice test might very well weigh in the defendant's favor in something like that. So I think that there is still an assessment based on what the prior crime was and whether it was relevant to the current charged offense.
One of the claims, as I understand it, is that one of the reasons are put forward why this might violate Section 10 is that it deprives the defendant of the ability to challenge witnesses against him. And it strikes me in the discussion you just offered that that would be one of the reasons why that constitutional protection is important. And so how would you respond to that?
Well, I think that a couple things. Obviously, it's a case-by-case basis, and in this situation...
Well, it's not, though. The Constitution says you get the right to challenge witnesses against you. It's not case by case.
Well, to that extent, obviously, if there's been a prior conviction, the defendant obviously did have the right to confront witnesses in that.
But
prior
arguably
proceeding.
not in the trial at issue. You're trying to bootstrap in the past right to challenge witnesses and just want to say, well, now we just get to put the fact of the conviction before the new jury.
I don't think that that's unique, though, to this context with 455 evidence. I mean, obviously, there are other situations where a defendant's prior convictions are allowed into evidence, whether it's for enhancement or something to show that somebody, for instance, has a prior conviction that prohibit him from carrying a firearm.
I understand that, but to me that doesn't answer the question, because if that's unconstitutional, it might be unconstitutional in those cases as well. I'm looking for your best argument why that doesn't violate the prohibition on
Confrontation.
Essentially, yes, the confrontation.
And I think my best answer is that they already confronted them. I mean, the right to confrontation doesn't mean that once you're convicted of something and have had the right to confrontation that you then just get, I mean, again, we can take it in another context. Then at sentencing for criminal history purposes, does the defendant get to bring it? I mean, the defendant doesn't have a right in every case to then say, well, these prior convictions, I want to be able to...
There is a difference, though, I think, here, counsel, that might matter. In a sentencing, for example, just the fact of the conviction normally is enough. That's all the state has to show. Here, the state doesn't usually just want to say there was a conviction, does it? It wants to put on some more. It wants the jury to hear a little more, right? A little bit of the circumstances of the crime, the previous crime. I mean, that does happen a lot in these cases,
It does
right?
happen some, although I would note that this case was an example where I think it essentially came in through just a stipulation.
But there's a variation there, isn't there? And so does that mean that any rule we come down with in this case ought to include provision for limitation of what can be admitted in order to prevent running afoul? The provision my colleagues suggested might come into play.
I don't know that it would be necessary to specifically fashion a rule for that, because again, I think that does, to some extent, that already gets done as part of the probative prejudicial
But
test.
not for the reason he's suggesting, to avoid running afoul of Section 10.
Right. Again, I guess I just can't get past the fact that when you're in a situation where you're admitting evidence of a prior crime that the defendant has been convicted of beyond a reasonable doubt by a jury in a proceeding in which he did have full rights to confront the witnesses against him at that stage, I guess I don't see how that could be a true violation.
Well,
of the right.
conviction, the fact of the conviction, I would agree with you. I think that you get into a little bit deeper water.
And I would agree with that. And I think that certainly as the state, we have to be careful that we don't turn these cases into just a parade of
retrial
witnesses
of
from
them.
something that happened 30 years ago.
I'm hearing this discussion, counsel. I'm curious where the following example might fall on this continuum. I'm assuming that given your practice, you've cross-examined some witnesses before and you want to prove that their testimony is not credible, and you've tried to introduce evidence of their prior convictions for crimes involving dishonesty.
I might have done that very limited number of times in my personal practice, but certainly have read hundreds of transcripts in which that's happened, so I'm familiar with it, yes.
And where does that fall on this continuum when such a practice is followed?
Well, clearly that is, in a situation like that, the witness, that comes in because it's relevant when somebody is offering testimony, goes directly to credibility. I think in a situation like that, I don't recall many instances where the witness is then able to go back and relitigate that prior conviction. I think they're simply asked, isn't it true that you were convicted of forgery, theft, or a crime involving dishonesty? And either answers yes or no, and then the trial moves on. So there's certainly not a full inquiry into it where that person is then able to challenge that prior conviction. They're just forced to answer whether or not it exists. So I think it's similar in the sense that you're not going to be able to relitigate or open back up a prior conviction in that sense. And much like in this case, I don't think that, again, that it would cause any constitutional concerns when you've already had a full opportunity to do that at the proceeding in which you were convicted of that offense.
And why do we allow that? You're using a prior crime, in a sense, to prove propensity for lying now. Is that a fair characterization?
Yeah, I think that would be fair. I think also just to phrase it that it's certainly something that naturally has a relevant tendency in trying to aid the jury in determining whether somebody is a credible witness. And I think along those lines, yeah, I think it is fair to somewhat represent that as propensity evidence of a sort. Much like in this case, the reason why it is allowed in 455D in sex cases is because, as this court recognized in Prine, the modern research, I think the exact language used by this court in Prine, one, was that the modern psychology of pedophilia tells us that propensity evidence may actually possess probative value for juries faced with deciding the guilt or innocence of a person accused of sexually abusing a child. Now, Prime 1 was only decided 9 years ago. So that language talking about the modern psychology of pedophilia, I don't think that in the 9 years since, that there's a big change there. And certainly the defendant has not even made such an argument.
That was just based on how the DSM defined pedophilia, wasn't it? Nothing deeper than that.
But nevertheless, it clearly was something that this court felt significant enough to recommend to the legislature that 455 needed to be amended in some way.
That presents kind of a modern view. The DSM wasn't available to our brethren back in the 1900s when an exception was carved out then. What's the rationale, even looking at this historically, can you just determine what the rationale was for carving out the exception for lustful disposition so long ago? Any idea about that? I look for it, just kind of said, it's in these kinds of cases, that's what we're going to allow. Anything beyond that?
I'm certainly not aware of whether back in the early 1900s or late 1800s, if there were specific scientific studies that had been done and that the court back then relied on. So I think that probably the best answer I can give you, which may or may not be satisfying, is that it was just kind of a common sense determination. at
What's
that
common
point.
sense about it, as opposed to any other crime?
Well, I think that there is a legitimate reason to believe that people who have a disposition to commit these types of crimes, because it is to some extent recognized as a disease of sort, pedophilia. I don't know that there's ever been anything proven to show that there's a group of people that has a disease that predisposes them to commit forgery or to burglarize.
What about kleptomania, which is a recurrent urge to steal, typically without regard for need or profit? Why isn't, if you have someone's suffering from kleptomania, wouldn't that prior thefts have the same relevance and the same propensity value as lustful disposition?
Well, two answers. One is that perhaps it could. And the second answer is that I really don't know that I'm able to go into a lot of detail because, again, this is not something that the defendant in either of these cases has raised. And I arrived today prepared to address the challenges that the defendant was making, and I did not spend a lot of time looking into that particular area.
Reviewing the DSM. We can think of some other disorders too, like oppositional defiant disorder and what have you, but your point's well taken. I have a couple more questions. It looks to me like some of those older cases just are kind of more about Victorian morality or the period immediately thereafter. Some extra moral judgment on a defendant's behavior in addition to what the law strictly requires. Would you agree with me on that?
I think clearly there's been a change
There's a
over the
flavor of
last
that.
century and the rationale perhaps,
Yeah,
yes.
there's a flavor. Here's my question. You started out by saying we need to presume constitutionality. And I want to talk about a different presumption, and that's the presumption of innocence. The way I understand your opposing counsel's argument, she's not arguing equal protection. She's not saying these defendants are similarly situated to other defendants and therefore, they shouldn't be treated differently. She's not making that argument that ends in a rational basis sort of analysis for this classification. She's just making a straight up due process. This process varies from what ought to be required for fundamental fairness. So I want to hear what you have to say about whether this statute impairs the presumption of innocence for these defendants when compared to everyone else.
Right. I don't think that it does because I think clearly 455 itself, even before the amendments, allowed for this type of evidence to be admitted when one of the factors in the statute was proven.
But it expressly forbade propensity as the reason
It
for
did.
everyone.
It did. But in those situations, the fact remains that the jury hears the evidence of the prior conviction and therefore is aware of that at the time that they're determining guilt or innocence of the charged offense. So while allowing it for propensity does take it a little bit further, obviously, my basic position would be that because you still do have the weighing of the probative and prejudicial value, and that it is filtered through a trial judge who is making sure that the state is not turning a trial into just a repeat of old accusations against the defendant. And I think especially in the case that we're here today on, and the next case for that matter, where the manner in which the 455 evidence comes in is so narrowly tailored, where it's either through a stipulation that the parties have agreed to, or it's through a detective that basically presents about a 2-sentence synopsis as to what the prior crime was for, that you're not running the risk of the trial simply becoming a trial based on what the defendant did in the past.
That kind of goes back to my other question about how strictly circumscribed what the state presents ought to be, perhaps.
And I think that, but again, I do think this case shows that the state and the trial courts are not doing the types of things that would be problematic. I think that if we were here on a case today where 150 pages of the trial transcript consisted of victims from 20 years ago coming in and testifying in great detail about what the defendant did to them, then the defendant would have a much stronger argument.
And we have seen those cases, though, where witnesses come in from previous
Right.
situations.
Is that I'm trying to envision a situation in which, and maybe you can give me an example, how would a district court abuse its discretion in weighing the prejudice and probative value and in allowing it in? Where would be an abuse? Is the description you just gave, is that an abuse of discretion? Just give me an example of how it would be an abuse of discretion to allow in propensity evidence in a case like this.
Well, I think the one I mentioned earlier, let's say that you've got a defendant who, as a 50-year-old adult, is on trial for sexual conduct with a 5-year-old child. And that in that trial, the state tries to get in evidence that when the defendant was a teenager, he was charged and convicted for having consensual sex with his 15-year-old girlfriend. If the trial judge in that situation simply looked at the state's proffer and said, well, that prior offense was a sex crime, so I'm going to let it in, without any further analysis or recognition of the fact that the crimes themselves are very different in nature and so far remote in time, that would be the type of case where, while I don't want to say flat out it would be an abuse of discretion, I think that's the type of situation where a defendant would have a strong argument in that regard if the court completely ignores any real assessment of whether that prior crime is relevant and probative and just rubber stamps it and allows the evidence to come in. That, I think, arguably could be labeled an abuse of discretion because the court essentially wouldn't be exercising discretion at that point. It would just be indicating that, well, in every single situation where the defendant has a prior sex offense, I'm going to let it in without any further inquiry into the prior offense. But I would also note, and I think the Ninth Circuit has spoken to this, because I know one of the arguments that the defendant has made is that, well, the problem is that the probative prejudice test rarely leads to the evidence being excluded, and therefore it's really no protection at all. And what the Ninth Circuit said to that in a case called LeMay at 260 F. 3rd at page 1026, and they were talking about Rule 403 in the Federal Rules of Evidence, which talks about the probative prejudice weighing that goes on there. And they said that as long as Rule 403 excludes potentially devastating evidence of little or no relevance, then rules permitting the admission of propensity evidence in sex crimes are constitutional. So unless it's a situation where allowing the evidence is so egregious and results in such a significant undue prejudice to the defendant, there won't be, I would admit that the state's position is that there aren't going to be a lot of cases where the defendant's going to be able to prove an abuse of discretion, but that doesn't mean that the statute's unconstitutional. As long as there is still that role for the judge to have discretion, that's not a constitutional problem. There are all sorts of issues that are reviewed for abuse of discretion on appeal, and the appellant always has a very difficult hurdle to overcome in those types of situations, but that doesn't mean that there's something unconstitutional or improper about the way that ruling is evaluated. Again, I think our position is that when you look at Kansas's history, which admittedly those opinions from 100 years ago read very differently as far as the language that they use and maybe the rationale, but when you couple that with this court's discussion in Prime 1, the fact that the legislature directly responded to that, and then when you look at all of the federal circuits that have addressed this issue, the weight of the case law throughout the country shows that this is constitutional. And the two states that the defendant has relied on, Iowa, notwithstanding what counsel argued today, I would argue is significantly different from us as far as their history in whether they allowed this type of evidence for propensity. And Missouri Missouri has interpreted their constitution differently than we have. And I would note that in a recent unpublished opinion, the Court of Appeals noted that Missouri has since amended their constitution to specifically allow propensity evidence in child sex crime cases. So faced with all of that authority and the fact that the defendant is just relying on 2 states that can be easily distinguished, I think that what the legislature did here in response to Prine 1 was perfectly appropriate. I think that the defendant still has the protections that are afforded by the probative and prejudicial test, and I think that the 2 cases that we're here on today show that both the state and the trial courts are not using the amendment to simply turn trials into an improper use of prior crimes evidence. People are still carefully making sure that it comes in only in the appropriate manner and in the appropriate way. And for all of those reasons, our position is that the amended statute is constitutional.
Do we have any questions of counsel? Thank you, counsel.
Thank you.
Okay. I have a lot. I'm not sure if I'll get through it all, especially if you all have questions. I'm willing to answer those. First, I want to talk about the confrontation right. The question of whether or not it's a, they've already been confronted for this conviction. They were convicted, and so it's already there. The law is pretty clear. The prior bad acts don't have to be convictions. They may not have ever been confronted by those charges. The state doesn't charge everything. And in fact, I've had cases where someone is actually acquitted of those charges, and then they are confronted with them later in another case as 6455 evidence. The concern about propensity evidence in this state, there's cases going back to 1878 indicating that there are concerns about why we use propensity evidence against defendants when they're not charged in that case with that crime.
There's the cases where the exceptions were beginning to be carved out. The court talked about the part of the rationale being that sex crimes lack concrete evidence that a crime was committed, and that propensity evidence is therefore more demonstrative and necessary than propensity evidence in other kinds of prosecutions. Mm. That seems to be one of the rationales that existed early on. Do you have a comment about that? That's not a basis to begin to carve a rationale, that the lack of concrete evidence is that an exception that was recognized then? What do you think about it now?
I would say that the lack of concrete evidence is, I guess, frankly, not the defendant's problem. That's the state's problem. And if they don't have the evidence to prove their case, and they're relying on a prior crime to prove their case, I think that that's a problem in and of itself.
It's kind of telling, isn't it?
Yes.
Yeah, I think we've addressed that in some of our earlier 455 cases when we said that the corroboration of a witness wasn't really a way to get 455 evidence in.
Right, and I will, in this case, the court did find that in addition to propensity, the evidence could be put in to prove many other things. And that, I think, is proper. The problem then becomes that there's no requirement of a limiting instruction. I take my opposing counsel's point that we're allowed to put in all this stuff to prove all these other things, and that causes the same confrontation problem and things like that. But it doesn't, because we tell the jury this evidence can only be used to prove motive. If propensity is one of the reasons that the evidence is allowed in, there's no limiting instruction. The jury can use that for whatever purpose it has, and it's extremely difficult. I think that everybody would be aware that jurors have a hard. If I were a juror, I would have a hard time putting out of my mind the knowledge that this person committed this crime for the purpose of propensity, even though there may be other reasons. If I'm not told, only use it for this specific purpose. And so it's a compounding problem.
Doesn't your argument that this evidence can come in for certain purposes but not for other purposes? That's your argument. Doesn't that undercut your confrontation clause argument? Because if it can come in for some purposes,
Right.
and that's fine, then you don't have a confrontation clause problem.
I admit, when I was sitting at council table, struggled with this in my head, and I think that the best answer that I have for that is that first, it does actually cause the court to wrestle with the actual facts of the case, the prior case, in relation to this case, and that we're limited in the purposes in which we can use that evidence. We can't just say, well, he's committed sex crimes before, so he's probably committed this sex crime, which...
I'm just saying the heart of your argument is the purpose for which the evidence is introduced, and that has nothing whatsoever to do with the right of confrontation. Because if the right of confrontation is violated, it doesn't matter what purpose it's entered for. How am I thinking incorrectly about that?
I guess I don't really have an answer off the top of my head for that question.
Just before you sit down, the facts of this case were pretty strong. We have an eyewitness to what occurred
without getting into the specific details.
Right.
Saw what happened. What is then the prejudicial effect of this evidence when the evidence was so strong? I understand in a case where there's less evidence, there's just one word against another. There's not the scientific corroboration that sometimes exists in these cases. But here, evidence was pretty overwhelming of what occurred. What was would you say the prejudicial effect in this case was less than it would be in a different case? Because
I guess I
While you're answering that, why don't you also give the probative effect? Because if you have overwhelming evidence, why you need to bring in prior crimes, so you can balance it both ways.
And I will first say that it's a lot of my experience that the state introduces evidence and probably can prove cases without that. And so it just is compounding on top of evidence that they already have, which is actually one of the factors that the court in LeMay asked them to consider when they're deciding when courts are deciding whether or not to introduce evidence. But in this case, my argument would be that the eyewitness, as far as the mother, her testimony, her statements to the police differed from testimony, and there were some credibility issues there. I think so I think that there's problems with her testimony. And then there's questions about the testimony of the 6-year-old girl. So I don't know that the evidence is really just as strong as it could be, but that would be my argument as to why it's prejudicial.
In conclusion, counsel, what are you asking this court to do for you and your client?
I would ask this court to find that KSA 6455D is unconstitutional under the Kansas Constitution for reasons set forth in my brief and in argument today, and remand for retrial because it was allowed in for propensity purposes. That is my request today.
All right. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.